Welcome back. We're with Professor Scott Gerber, who's given us a lot to think about in part one. This is part two, and we're going to talk about two topics. One, the newest justice, Ketanji Brown Jackson, who starts in October making decisions, I guess, or at least sitting on the bench. And then Clarence Thomas's increasingly prominent role and what that might mean for the coming affirmative action cases. And I think I get 15 minutes. I'm not sure. They'll stop me because it's the free program. So let's go now to Justice Ketanji Brown. You actually wrote an op-ed. What is her judicial philosophy? Why don't you summarize that for us?
Okay, so after her confirmation hearing, or that the day it ended or something like that, I published a piece in the USA Today where she claimed that her judicial philosophy was her judicial methodology. So what she did as a judge was learn the facts, apply the law, and be impartial. And so I said that's problematic because you cannot apply the law unless you have a theory about law. And you need a theory about law for interpreting the Constitution, for interpreting statutes, and for interpreting cases. And so I concluded that she seemed like a nice person and a bright person, but she owed it to the American people to actually tell us what her judicial philosophy is. In the prior segment, we talked about Scalia's textualism and originalism, and Chief Justice Roberts' doctrinalism, Breyer's prudentialism, and Sotomayor's moralism, etc. So it's impossible not to employ something like that. And so we're entitled to know whether she's an originalist, for example. I know she's not, but we're entitled to know. Barrett said she was an originalist and a textualist. She told us, okay? And she's voted and written opinions through that lens, through that method. And so Jackson didn't do that.
What if she were to reply, okay, Professor, I'm a pragmatist.
Okay, that's fine. Richard Posner, the greatest appellate judge in American history, was a pragmatist. He wrote 50 books literally about pragmatism. And that's okay. Breyer is a pragmatist. That's okay. She doesn't have to be this or that, but I think she felt she had to be this or that, or she might not get the votes she needed.
I thought you said Breyer was a prudentialist.
Same thing.
Oh, I didn't know that.
Yeah. It's focusing on the consequences of a decision. That's what a pragmatist does. And so that's just a synonym, at least in law, for prudentialism, for policy.
I had no idea.
Yeah. So I just felt that she should tell us, more importantly, tell the Senate, so they could decide whether to confirm her. But I think they're just, as long as they seem nice and don't say something really stupid, I think they're banking on the fact they'll get confirmed. And
Well,
that's
also,
what
didn't she go to Harvard Law School, and her husband was like 6th generation Harvard, and et cetera? I mean, I think it's pretty top tier, high society there.
Yeah, but her parents were school teachers, though, so she didn't come from silver spoon kind of thing. But she went to Harvard for college and law school.
Because isn't that one of the other things I think you've written, or I've heard you speak about it? There are too many Harvard and Yale law grads on the Supreme Court. Is that not from you?
That is from me. That is from me. I mean, this is what I do for a living. I interact with people that went to Harvard and Yale because they dominate law teaching also. And some of them are, terrific, rocket smart, intimidatingly brilliant, like Richard Epstein, people like that. But for the most part, nah, not really. They just took a good standardized LSAT test or something like that. And so I also think if you go to a different type of law school, you get a different education, a different way to approach things. So, and as I've said countless times, these people are not like Cardozo in terms of just sheer brilliance that everyone recognizes it. So you got to put them up there. None of them are like that. I think Scalia probably was just sheer intellectual horsepower, but the rest of them, no. Are they bright? Sure. But there are lots of bright people in the world, and they don't all go to Harvard and Yale Law School.
Okay, this might be a good way to segue to our final topic, which is of great interest to me because that's how I met you as the Clarence Thomas expert. Clarence Thomas did go to Yale Law School, and I actually was very impressed by the decision I read that had his name on it, and I was just wondering what you think, because I remember in an earlier interview, I said, oh, I always thought Clarence Thomas was silent, never spoke, and didn't, and now he seems to be the dominant figure who presides over the court, putting everyone else into, they look like midgets compared to him. What do you think of his increasingly prominent role, and what will it mean for next term, including the affirmative action cases you see coming?
Yeah. Well, Clarence Thomas is very bright. I mean, as I've said, they're all very bright, but there are lots of very bright people. So he's very bright. He's a hard worker. In terms of his impact, there's two things I want to say about that. One, it is true for a long time, for years, he didn't ask questions during argument. There were always newspaper stories about that. Oh, that implies that he's not intelligent enough to come up with a question. I mean, that's a stupid thing for a reporter to put down on paper. He's clearly smart. But the reason he didn't was he felt his colleagues asked too many questions. And he wanted the lawyers to have a chance to make their case. And so Scalia would ask too many questions. Breyer would ask too many questions, et cetera, et cetera, et cetera. And so he just wanted the lawyers to catch a break. And so he kept quiet. And then I also think at some point, given the fact that he was getting so much heat for not asking questions, he just said, I'll show you, I'm not going to do it, right? But now when the COVID hit, they were hearing arguments by phone. And so Chief Justice Roberts instituted an approach where he just called on people by seniority. So Thomas would get called on first because he's been there the longest. So Thomas then would ask questions because he has questions, okay? And then now that they're back to hearing arguments in person, I think he actually enjoys asking questions. And so he's still asking questions. So there's that part of it. But then on the other part, when I wrote my book about him years ago, it was the first book about his legal theory. And most of the book was about the separate opinions he would write in concurrence or in dissent, not majority opinions. And the reason was because people weren't signing on to his opinions a lot of times. Even Scalia wouldn't sign on to some of them. And so, but and this relates to something I said at the beginning of our prior segment here, the younger lawyers and judges were socialized and professionalized in a conservative legal movement that actually read Scalia and Thomas's opinions. That's what they were schooled on, right? And so Scalia and Thomas would give speeches at these dinners and the like. And so they read them, were impressed by them, and agreed with them. Okay, and so now these people are judges, and now some of them are Supreme Court justices. And so they agree with how he approaches it. So things he used to say in dissent, he now gets to say in a majority opinion. And I think that's going to bear the clearest fruit in the affirmative action contest, because he's written a lot of separate opinions saying that the Constitution should be colorblind, that you cannot use racial preferences, for example, in higher education admissions decisions. And now there's 2 cases, one out of Harvard, one out of the University of North Carolina, on the court's docket next year. And I think the court's going to overrule the affirmative action cases and say you cannot take race, gender, and ethnicity into account at all in admissions. They've already said it in hiring, but people always ignore that. But in admissions as well. And so he will have won because he's been making that argument since he was the head of the EEOC, which is more than 30 years ago. So that's a huge thing, especially in what I do for a living. I work in higher education. And the colleges and universities in America are just going to go ballistic. They're not going to know what to do because they're not going to be allowed to do what they do too much of already. They won't be allowed to do it at all.
Haven't they already prepared for that? I went to the University of California. The University of California has just eliminated their SAT tests, and they're going to a whole other system where, in other words, you're going to get a different way of selecting students that's not explicitly race conscious, say, but will presumably result in a different mix than just taking the top performing students on tests or whatever it is prior. A similar thing happened. My father went to City College in New York. They went to open admissions. And then my wife went there subsequently after open admissions. And they still had some very good professors, but there was a very mixed bag of students. It was no longer a top tier college. One of the things is in terms of selection, there could be many workarounds. I mean, what do you see that as a possibility?
Yeah, it's pretext. They're getting rid of those tests because they know that they won't get the student composition that they want.
I mean, what if the argument is colorblind systems might actually result in racial and sexual disparities in and it may well be there are more women in the English department than there were more men in the engineering department. But under certain views, colorblindness, I think they say it now explicitly, is racist.
Yeah, I'm not Charles Murray. I'm not making this argument that there's a difference in levels of intelligence. What I think the problem is that a disproportionate number of non-white kids aren't getting the primary education they need.
Well, it's not a matter of white or non-white. I mean, Asians outperform whites on most tests, and certainly in math and the hard sciences. So, I mean, that's actually goes the other way. But the point is, if Clarence Thomas sticks to his guns, and you say this is a principle he believes in as part of his judicial philosophy, colorblindness. And I happen to be colorblind, but I'm red-green colorblind. But the point is, do you see, if he carries the court around it, there'll be some kind of resistance, shall we say, to it?
Do I think that he's going to write the majority opinion?
I don't know. Will he?
Is that your question? Do I?
It's one of the questions.
Yeah, I think the answer is yes. I think it's going to be 6-3. That the court's going to prohibit the use of preferences based on race, gender, and ethnicity in higher education admissions decisions. And I'm not alone in thinking that. Most people think that study the court for a living, especially after the term that just finished that we're talking about.
Well, you called Roe versus Wade, so I think you're a pretty good handicapper of these things. So and if that happens, what do you see the reaction being? If we become a colorblind society, officially?
Well, I in terms of higher education, which is what the cases are about, I think that a lot of colleges and universities are going to violate the law. And they already do it. You know, the court has already said you can't use race or gender to ethnicity in too heavy-handed a way, right? In admissions and in hiring, you can't use it at all, right? You can't use it at all, but that's essentially all they use it. That's all they care about. You know, do you check this box or that box? So they consider things and they emphasize things that by law they're not allowed to consider at all. We talked about this the first time we spoke. So I just think there's going to be more of that. And that's just going to lead to more lawsuits. And if people object to these practices, at their college or university, they get retaliated against. They get lied to first, and then they get retaliated against for catching them in the lies. That's how it works. It's not pretty.
And what kind of procedural? I noticed in one of the cases, Justice Thomas referred to the 14th Amendment Equal Protection Clause. What kind of protections do people have if they violate the laws?
So what are you saying?
Well, let's say there's a ruling, educational admissions have to be colorblind. Okay. Then they go, that's fine. Like President Jackson, how many troops does the Supreme Court have? Or the Bakke decision is a famous case where in effect, it had no effect. I mean, there is no result.
I'm not sure what your question is. So are you saying?
So what happens next? So let's say Clarence Thomas writes the decision saying, let's go be a colorblind society. That's what the founders wanted. That's what all men are created equal means. Okay? Where do we go from there? What happens next?
Well, again, I'm focused on higher education. That's what the case is.
Okay, what happens next in higher education? So they violate the law. What are the consequences?
For violating the law, it just depends on the integrity.
What's the penalty? What's the penalty?
Right. It depends on the integrity of the people running these places, and it depends on who's doing the violating. So if I was the president of a university and I found out that a dean of one of my colleges was violating the law, I would terminate the person. I would first make sure that was in fact what was going on. But if it was, I would terminate the person. You can't have administrators violating the law. You can't do that. But if the problem is with the president himself or herself, it's up to the board to do something about it. Okay. And if they won't do anything about it, someone has to blow the whistle, and then the government has to do something about it. But because the government is so overworked and understaffed, they usually don't do anything about it. So when it comes down to it, my guess is that a lot of colleges and universities will continue to violate the law and they'll get away with it. If it's Yale or Harvard or UNC, places like that get featured on the news, I think they will be careful not to do it. But if it's these thousands of other colleges that fly under the radar, I think they'll just do it because they think they can do away with it. But they have to sleep at night. We've had that discussion before. They have to sleep at night. If they think that they're allowed to violate the law just because they can get away with it, shame on them. But there's nothing I can do about it other than to call them out on it sometimes.
But I mean, is there anything Justice Thomas can do about it in writing his decisions?
No, he's just going to say, stop using it. And he's going to explain why. And he's going to there'll be 6 votes. And then it's up.
Well, not if they remove Gorsuch and Kavanaugh like you suggested.
Well, that's true. Okay. So that would change the vote. So, but they're not going to remove them. They're not going to do it just because I say they should do it. Doesn't.
I don't know.
Well, they've never removed the Supreme Court justice. Samuel Chase got impeached by the House, but he wasn't removed by the Senate. So it's very rare. We have all of these checks in place, but they don't work. It's just another example of the government is dysfunctional. It doesn't work.
Well, one thing that does work is your predictive powers and your analytical powers, because I think this has been very enlightening. I want to thank you. I'm certainly going to stay tuned because I personally, I was in higher education. I have a PhD. When I got my PhD, one of my committee said to me, well, as a straight white male, you'll never get a teaching job in the United States. You might think about going to Australia. And I went, huh? And turned out to be correct. So perhaps it wasn't discrimination, but since that was said and then it happened, and if your intellectual or academic work is irrelevant, it creates certain disincentives in the system to do good academic or intellectual work and focus on other things. So we'll see. I would certainly be very pleased if your prophecy comes true, as it did with Roe versus Wade. But I don't know. You don't think there's a chance they'll pack the court before then?
No.
Oh.
I think that the Republicans are going to take the Senate in November. So how are they going to, they'll never get something through. They'll probably take the House also. I mean, look at how much are you paying for gas, Larry? Down your way.
$4.79.
Yeah. I mean, my God, you can't, inflation is crazy. And this is a different topic, but people are mostly concerned, voters are mostly concerned about economic things. And inflation's out of control, man, and people are hurting. So I think that the Democrats are going to get blamed for it, and Republicans are going to take the Senate and the House. So, and if they do that, they can't pack it. And I don't even think Biden, I think he still opposes packing it, to his credit. So they won't do it.
Okay. Well, that's good to have down. I'll come back to you after the election and we can see what's going to happen next. Because it's, I guess, does the court ever release an opinion in October, or do they always wait till June?
No, it won't be October, because the first Monday in October is the first day. So, but they release them spread out over the term.
I mean, could we have a decision on affirmative action before the election?
No. It's too big a case. The big cases usually take until the spring to come out.
All right. Well, we'll keep our fingers crossed. And I thank you again for a fascinating analysis. We'll be following you at the New York Post, on your website, at Ohio Northern University. And I sort of, in the back of my mind, am waiting for you to testify to the Senate Judiciary Committee why you think they should impeach Gorsuch and Kavanaugh. I mean, that would be incredible. But you say it's not going to happen, so it's academic at this point.
Right.
All right.
All right. Thanks, Larry. Have a good one.
Thank you very much. That was great.
All right. Bye-bye.
Bye-bye.